The International Migration Law and Introductions. Introductions to International Migration Law, current legal landscape, defining international migration law, customary law, immigration control, and state sovereignty, legal frameworks and provisions, some of the landmark cases, and the balancing of state sovereignty and individual rights. The field of international migration law is a complex and often misunderstood area of legal study. This presentation aims to provide some of the general examinations of the legal framework governing the transnational movement of persons under general international law. The subject of migration is inherently both a domestic and international concern, as it involves the movement of individuals across national borders. Traditionally, the admissions of non-citizens has been considered a matter of domestic policy, falling within the sovereign prerogative of each state. However, the international dimensions of migrations cannot be overlooked, and it is this aspect that forms the focus of this analysis. The legal framework for the movement of persons is fragmented across various branches of international law. This includes a specialized branch of trade law, which regulates international trade between countries, maritime and air law, which governs activities in international waters and airspace. Criminal law deals with crimes and their punishment. Nationality law, consular and diplomatic law, refugee law, human rights law, humanitarian law, labor law, and etc. This fragmentation poses significant challenges to the understanding and applications of existing norms. To address this issue, the concept of international migration law has been proposed as a discrete field of international law. This approach aims to provide a comprehensive, coherent, and contextual framework for analyzing the transnational movement of persons. International migration law can be defined as the set of international rules and principles governing the movement of persons between states and the legal status of migrants within host states. It encompasses the entire migration cycle, such as departure from the country of origin, entry and stay in the foreign country, and the return to the country of origin. A significant portions of international migration law is rooted in customary international law. This body of law is derived from the general practice of states accepted as law, the so-called opinion iure. Two key areas of customary law in this field are the right to leave any country, including one's own, and the admissions of migrants, the immigration control, and state sovereignty. The right to leave any country, including one's own, is widely recognized as a fundamental human right and a well-established principle of customary international law. It is customary nature, its customary nature is evidenced by first widespread state practice, numerous international treaties, compilations of national legislations, case law, and the soft law instruments. Key legal instruments affirming these rights include Universal Declarations of Human Rights, UDHR, under Article 13, Clause 2, International Covenant on Civil and Political Rights under Article 12, Clause 2, International Conventions on the Eliminations of All Forms of Racial Discriminations, Article 5D2, Conventions on the Rights of the Child, Article 10.2, international conventions on the protection of the rights of all migrant workers and members of their families under Article 8, Clause 1, European Conventions on Human Rights, Article 2, Clause 2 of Protocol Number 4, American Conventions on Human Rights, Article 22, Clause 2, African Charter on Human and People's Rights, Article 12, Clause 2, Arab Charter on Human Rights, Article 27, Clause 1. The customary nature of this right is further supported by consistent state practice, similarity of treaty wording, rare reservations to relevant treaty provisions, numerous resolutions and declarations endorsing the right. It is important to note, however, that while violations of this right still occur, it is difficult to conclude that it is more frequently violated than any other customary norms. The competence of states to regulate the entry of non-citizens has traditionally been considered a well-established principle of positive international law. It is grounded in the concept of territorial sovereignty. However, this conventional wisdom is challenged by historical evidence, such as free movement across borders has long been the rule rather than the exceptions in the entire human history. Immigration control is relatively recent inventions of modern states, emerging at the end of the 19th century in certain countries and for a specific category of aliens, non-citizens. Despite the traditional assertions of state sovereignty in this area, general international law does provide some limitations regarding refusal of entry, procedural guarantees governing immigration control. These limitations are crucial in balancing state sovereignty with individual rights and international obligations. The principle of non-refoulement is it prohibits states from returning individuals to countries where they may face persecutions, torture, or any other serious human rights violations. It is enshrined in 1951 Refugee Conventions under Article 33, the United Nations Conventions Against Torture under Article 3, European Conventions on Human Rights, as interpreted by the European Court of Human Rights. The prohibitions of collective expulsions can be found in European Conventions on Human Rights under Protocol Number 4, Article 4, American Conventions on Human Rights, Article 22, Clause 9, African Charter on Human and People's Rights, under Article 12.5. The principle of family unity, recognized in various human rights instruments such as Universal Declarations of Human Rights, UDHR, Article 16, International Covenant on Civil and Political Rights, ICCPR, under Article 23. The right to seek asylum is generally recognized in UDHR under Article 14. There are also various regional instruments, such as the right to consular assistance, codified in Vienna Conventions on Consular Relations under Article 36. Several landmark cases have shaped the interpretations and applications of international migration law. Legrand case, Germany versus United States of America, the International Court of Justice in 2001 affirmed the individual right to consular assistance under the Vienna Conventions on Consular Relations. Hirsi Jamal and others versus Italy, the European Court of Human Rights in 2012 extended the applications of the principle of non-refoulement to extraterritorial contexts. Advisory opinion Inter-American Court of Human Rights in 2014 elaborated on the rights of migrant children in the context of immigration proceedings. MSS versus Belgium and Greece, the European Court of Human Rights, 2011. address state responsibilities in the context of the Dublin system for asylum seekers in the European Union. International migration law is a complex and evolving field that seeks to balance state sovereignty with individual rights and international obligations. As global migration continues to increase, the importance of a coherent and comprehensive legal framework becomes ever more apparent. The customary law foundations of international migration law, particularly the right to leave any country and the limitations on the state discretions in admitting migrants, provide a crucial basis for understanding and applying this area of law. However, the field remains fragmented across various branches of international law, presenting challenges for both scholars and practitioners alike. Moving forward, it is essential to continue developing and refining the concept of international migration law as a discrete and distinct field of legal study. This approach can provide a more holistic understanding of the legal issues surrounding migrations, facilitating better policy making and ensuring the protections of migrants' rights while respecting state sovereignty. International migration law is complex and it is often overlooked because of its dual nature. It involves domestic and international concerns or scopes. On one hand, the admissions of non-citizens is traditionally within the domestic jurisdiction of each state. On the other hand, the movement of persons across borders inherently involve international relations, creating a triangular relationship between migrant, the state of emigrations, and the state of immigrations. This duality is further complicated by the fragmentations of legal norms governing migrations, which span various branches of international law, such as refugee law, human rights law, labor law, and some others. The current legal framework resembles a giant unassembled juridical jigsaw puzzle, with numerous pieces scattered across different legal disciplines. Assembling these pieces under the umbrella of international migration law is crucial for providing a comprehensive, coherent, and contextual framework for analysis. This approach promotes a systemic understanding of migrations, encompassing the movement of persons between states and the legal status within host states. The right to leave any country is a fundamental aspect of international migration law, rooted in the philosophy of natural law and classical liberalism. Historically, this right has been recognized as an essential attribute of personal liberty, allowing individuals to escape prosecutions, seek better opportunities, or pursue personal motives. The right to live any country has a long historical pedigree, grounded in the writings of classical authors such as Victoria, Grotius, and Vattel. These scholars argued that the right to travel and emigrate was an integral part of national law and the law of nations. Over time, this principle was enshrined in various domestic legislations and international treaties, reflecting its importance as a fundamental human right. Today, the right to live any country is protected by a wide range of universal and regional human rights instruments. At the universal level, the International Covenant on Civil and Political Rights, the ICCPR, reiterates this right in Article 12, Clause 2. Other significant treaties include the International Conventions on the Eliminations of All Forms of Racial Discriminations, ICERT, the Conventions on the Rights of the Child, CRC, and the International Conventions on the Protection of the Rights of All Migrant Workers and members of their families. At the regional level, this right is reinforced by instruments such as European Conventions on Human Rights, the American Conventions on Human Rights, and the African Charter on Human and People's Rights. These treaties collectively ensure that individuals can exercise their right to live in any country, subject to lawful restrictions necessary to protect national security, public order, public health, or the rights and freedoms of others. Historically, the movement of persons across borders was relatively unrestricted. However, the introductions of immigrations controls in the late 19th century and early 20th century mark a significant shift. These controls were initially motivated by racial and economic considerations, later reinforced by wartime legislations and economic crisis. Today, the competence of states to regulate admission is recognized under international law, subject to certain limitations. Key norms include the principle of non-refoulement, which prohibits the return of individuals to countries where they face a real risk of prosecutions or serious human rights violations. This principle is enshrined in various treaties, including 1951 Refugee Conventions and its 1967 Protocol, as well as the Conventions Against Torture, CAT. Additionally, the right to family reunification is recognized under international law, particularly in relations to children. This principle is grounded on the right to respect for family life, as articulated in instruments such as ICCPR, the ICRC, and regional human rights treaties. Sojourn of migrants. The treatment of migrants within host states has evolved from traditional law of state sovereignty, state responsibility, to a more robust framework grounded in international human rights law. The concept of minimum standards for the treatment of aliens emerged in the late 19th and early 20th centuries. It provides a baseline for state responsibility. These standards included the right to life, protections from arbitrary detentions, and the right to a fair trial. Today, international human rights law provides a comprehensive framework for the protections of migrants. Key principles of this area of law include non-discriminations, prohibitions of torture, and inhumane or degrading treatment, and the right to an effective remedy. These principles are enshrined in universal instruments such as the ICCPR, ICESCR, the Conventions on the Rights of Persons with Disabilities, as well as regional treaties like European Court of Human Rights, African and American Conventions on Human Rights. International migration law is a complex interplay of domestic and international norms. While states retain significant discretions in regulating migrations, their actions are constrained by a robust framework of international human rights law. This framework ensures that migrants' rights are protected throughout the migration cycle, from departure to admissions and sojourn. By understanding and applying these principles, states can better manage migrations in a manner that respects the dignity and rights of all individuals, fostering a more just and humane global order. Migration is a questions of both domestic and international concern. On the one hand, the admissions of non-citizens is traditionally considered a matter of domestic jurisdictions for each state. On the other hand, The movement of persons across borders is inherently international, involving a triangular relationships between a migrant, a state of emigrations, and a state of immigrations. The right to live. The right to live any country, including one's own, is a fundamental human right enshrined in international law. This right is derived from various sources, such as Article 12 of the Universal Declarations of Human Rights, Article 13 of International Covenant on Civil and Political Rights, and various other United Nations treaties or regional human rights conventions. The right to live has matured into a norm of customary international law, evidenced by the widespread and representative participation of states in relevant treaties, similarity of treaty wording, rare reservations to the right, and numerous resolutions and declarations endorsing such right. This, despite the traditional assertions of state sovereignty, general international law provides some limits regarding refusal of entry and procedural guarantees governing immigration's control. These limits include the principle of non-refoulement, non-refoulement, which prohibits states from returning individuals to a country where they face real risk of prosecutions or serious harm. The right to a fair hearing in immigration proceedings, the right to consular assistance for foreign nationals detained or arrested in foreign country. Once a migrant has been admitted to a host state, the legal status is governed by a complex interplay of domestic and international law. The host state has a wide margin of discretions in determining the legal status of migrants, but this discretion is not absolute. International law imposes certain obligations on host states, including the obligations to respect the human rights of all migrants, regardless of their legal status, the obligations to provide access to essential services, such as the healthcare and education, the obligations to protect migrants from exploitations and abuse. International migration law explores the ambiguous role of international law in the field of migrations, the concept, and the three essential features of migrations: the right to live any country, the admissions of migrants, and the legal status of migrants within the host state. The right to live any country, including one's own, has a strong foundations in customary international law, evidenced by widespread endorsement in human rights treaties, non-binding resolutions, and domestic constitutions. Regarding the admissions of migrants, the conventional wisdom that this is an absolute prerogative of state sovereignty. While states do have a wide margin of discretions in regulating the entry of non-citizens, general international law imposes certain limits and procedural guarantees to prevent arbitrary or discriminatory decisions.